Thank you.
SJC-11396, Town of Hanover, the New England Regional Council of Carpenters.
Thank you.
Good morning. May it please the court, I'm Christopher Soros. I'm representing the New England Regional Council of Carpenters. And the Carpenters, the council is asking this court to reverse the decision of the motion judge below, denying a special motion to dismiss under the anti-SLAPP statute, to award attorney's fees on this appeal, and to remand the case to the Superior Court for further proceedings, including an assessment of attorney's fees in connection with the motion. This case, brought by the town of Hanover against the council, involves an abusive process claim. And what the town of Hanover is alleging in its complaint, and these are only allegations, that although the council itself was not a plaintiff in the 10 taxpayer case, Fordyce against the town of Hanover that was before this court several years ago, the council, and I'm quoting from the complaint, actively commenced and prosecuted that litigation.
At the time that the Fordyce case was brought, was the role of your client known, or the alleged role of your client known, that is in sort of involving in trying to find plaintiffs to bring that case?
Well, there's nothing in the record of this case at all, or I believe in the Fordyce case, although I'm not sure about that. I haven't thought about that aspect of it. But there's certainly nothing in the record in this case even indicating that the council had any involvement at all in the Fordyce case.
Right, but I mean, isn't part of your argument, certainly the argument that the ACLU makes, is that regardless, I mean, let's just say you had banners up saying, we're doing this. That's perfectly appropriate because that's what organizing is about.
Yes.
And that's, so I just wondered as a factual matter whether it was or wasn't known.
I don't know whether it was known. My assumption is that it was generally understood. I think that would be a fair statement, and I don't imagine that my brother would disagree with that. What Hanover is alleging in this case is that the council, rather than be a plaintiff itself, because it didn't have standing to bring a 10 taxpayer case, used 10 Hanover residents to establish that standing, and that the council, though, exclusively controlled those plaintiffs, and that again is a quote from the complaint in this case. Hanover further alleges that the council's objective was to void the contract between Hanover and Callahan, the general contractor, so that Callahan would be replaced with a more union-friendly general contractor. Hanover further alleges that the standing requirements were not met in the Fordyce case because it claims that 2 of the named plaintiffs didn't really want to be or didn't want to remain at some point plaintiffs in the case, and therefore there wasn't standing, or there was a defect in standing.
There was no point, I know the record indicates that at least one of them did leave as a plaintiff but was replaced by somebody else.
That's correct.
Was there any point in the history of the Fordyce case itself that there were not 10 taxpayer plaintiffs who wanted to be 10 taxpayer plaintiffs?
No, there were several motions to amend the complaint in the case. One of them involved just a typographical error. One of them dropped a plaintiff and added another plaintiff. Another amendment dropped one and added 2, and another amendment added yet another plaintiff. So there were always at least 10, and And in the end, there were
But
12
willing and
plaintiffs.
able, 10 willing and able and knowledgeable, knowing what they were doing plaintiffs.
Yes, and I don't believe that the town contends otherwise.
Let's say there weren't. Let's say that your client decided that bringing a lawsuit, a 10 taxpayer lawsuit, was important to their strategy to have the contract set aside. Forget about the reasons they wanted the contract set aside. And let's assume that they just went down the list of their members that lived in the town and put those names on it and filed suit. Different case?
I don't think that's a different case at all, really.
An abusive process case to file essentially a bogus suit?
No, I don't believe it is, Your Honor, because the standard for an abusive process claim is that the plaintiff in the case used process for an ulterior motive. And the ulterior motive issue requires a showing of conduct as this court, in fact, I believe, in your opinion, in the Fabre case noted, conduct independent of the petitioning that indicated that there was an objective to use the litigation to secure some collateral objective in some coercive manner against the defendant with respect to outcomes that were unrelated to the outcome of the litigation itself. So I don't think that would be any different than a plaintiff filing a lawsuit that did not have a reasonable basis of in fact or law.
So you're saying,
Go ahead.
Which is why
well,
I'm sorry.
okay, that's all right. Then you're saying the only issue here is standing because, let's assume hypothetically that NERC had standing for whatever reason. The substantive allegations that it would make against the contract were the same that the 10 taxpayers is making, were making?
Exactly, and in fact, Your Honor, as the town of Hanover itself conceded, before the litigation, before the 10 taxpayer litigation, there were proceedings before the Attorney General's
Right,
office.
so the Attorney General could have brought this suit, right?
The Attorney General presumably could have, and the Attorney General, in fact, intervened in the Fordyce case as a party, but the council was a party to that administrative proceeding before the Attorney General's office. It raised precisely the same arguments. The award of the contract was unlawful, precisely the same arguments that were pursued in the Fordyce litigation. The suggestion that the town of Hanover makes that the council had no legitimate interest or it wasn't pursuing a grievance of its own in allegedly bringing the Fordyce case, I think is entirely baseless. It was pursuing exactly the same interests. It didn't lose those interests just because it didn't have standing in a 10 taxpayer case. It maintained that interest and had the right under it had a constitutional right and a protected right under the anti-SLAPP statute to, at the very least, organize plaintiffs to file a lawsuit.
So let's assume all of that is true, correct. Again, let me go back to the sort of the bogus lawsuit. So let's assume the 10 taxpayers are simply names off a list, have never been consulted, but this suit needs to be filed right away. So it's filed, motion to dismiss filed based on the fact that the 10 taxpayers are not in good faith agreed to pursue the litigation, and it's dismissed for that ground. No abusive process claim?
There's no abusive process claim unless it's an essential element of an abusive process claim that the plaintiff in the case had an object of using the case to coerce the defendant to do something other than what would have naturally flowed from the outcome of the case. That's an essential element. It's an important part of the analysis of the Court of Appeals in the Keystone case, which I think is really very instructive with respect to the allegations in this case. The Court of Appeals said that under this court's decision in Fabre and other cases, that it's essential for the non-moving party in an abusive process case that comes up in the context of an anti-SLAPP statute for the non-moving party to produce evidence of an ulterior motive. There's no evidence, there isn't even evidence that there weren't 10 taxpayers. There weren't 10 bona fide taxpayers in this case.
I'm just trying to understand where the line is here between petitioning activity and activity that is outside of petition activity that might form the basis of a suit. And you're saying the filing of a lawsuit, no matter how bogus it might be, in other words, there's no real standing.
Right, that's right.
That's still petitioning activity. It's not conduct separate from petitioning activity that could form the basis of a suit.
Absolutely, that's absolutely the argument here, Your Honor, and that's exactly what the Keystone case says. If the council itself filed, it couldn't find 10 taxpayers, they found 9, and they added themselves, or they got 10 Boston plaintiffs to file a 10 taxpayer case against Hanover, it would be a baseless case. It would be subject to dismissal. It would also be subject to sanctions under Rule 11. But it wouldn't be an abusive process case unless there was some other independent conduct other than the petitioning. Simply filing a defective complaint because of lack of standing, lack of subject matter jurisdiction, no real facts to support the case, all go to the efficiency of, or the effectiveness of the petitioning and the merits of the petitioning, but they don't amount to something that's required under the abusive process standard.
So could you, and I'm forgetting the name of the case, and unfortunately I don't have your brief here. It's actually one that I think I might have written, but it's about the person who was writing the article in the North End.
Newspaper, yes.
The newspaper case.
Yeah.
So,
Who was just a paid reporter reporting the news.
but who had a real, personal interest in the issue that she was trying to pursue. So here, your answer would be, well, there's nothing in the language of 59H that says you have to be a party, right?
Right.
And actually, we did have a personal interest, or the council members had a personal interest. So is that the distinction?
Well, it isn't, I think, because the reporter was simply reporting something in a newspaper, and the court determined that that didn't amount to petitioning. What Hanover is alleging here is that the council actively commenced the litigation and actively controlled the litigation and prosecuted the case. It's really saying, what Hanover is really saying is, we're trying to hold the council liable under an abusive process theory that requires that the defendant have used process. And we've made allegations that allege liability as if the council actually had been a plaintiff in the case. I think that's a very,
Very different from that, and very different from Coburn, who was a witness paid for by the state.
Very different from Coburn. Coburn, I think, is a reflection of the court struggling with the question of, perhaps how remote from traditional constitutionally protected petitioning activity one can get and still be protected by the anti-SLAPP statute. I think it's an effort to draw some lines. And in that case, the alleged petitioning was rather remote and tangential from what is considered traditional constitutionally protected petitioning. He was a hired expert witness by the state itself in that case. We don't need to even undertake the analysis that the court did in Coburn to examine the connection with or the interest in the litigation, because Hanover here is really saying the council is liable because it basically
was a ghost. It was a ghost
yes,
plaintiff.
Exactly.
Now,
Literally.
am I correct that your position is that if we agree with you that you are exercising your right to petition by enlisting others to petition, that we don't need to reach whether or not they have satisfied the two showings required under Section 59H because they filed no affidavit.
That's correct, Your Honor.
So we don't need to accept your view that even if they had identified 9 persons who had no clue that they were the plaintiffs, that would necessarily mean that you would survive a slap motion if that were indeed the case.
If the council had named 10 Boston residents and simply filed the motion that it did without submitting affidavits that they were not Hanover residents, they were Boston residents, they've failed to satisfy the burden that's required by the statute to establish that the case was devoid of sufficient facts or law.
So you're saying that even if there was a right to petition, a defendant could still, a defendant could still prevail in this case to saying that we will survive the anti-SLAPP motion by saying you just took 10 names from the phone book and made them your plaintiffs.
No. What I'm saying, Your Honor, is that once the moving party makes the threshold showing that the case is based on petitioning activity, as the council has done in this case, the burden then shifts to the town, to the non-moving party,
Right.
to come forward with affidavits.
Right.
Showing that, well, they're really 10.
But my question is, if they had an affidavit which said these names were the first 10 names in the phone book in Hanover, and these people had no clue that they were being used in this way, they could prevail and defeat your motion.
Oh, if they had an affidavit, yes, I believe they would.
How would they defeat your motion?
Well, because they would show that the factual allegations, if the town of Hanover had responded to the motion with affidavits saying the 10 plaintiffs were actually 10 Boston residents,
okay.
they would be showing, the town would be showing that the allegations in the complaint supporting standing were devoid of a reasonable factual
But that's
basis.
not a 59H issue, is it?
That is a 59H issue.
I thought you just told me earlier on that wouldn't make a difference as to whether you could survive this motion.
Well,
Am I wrong?
I may have misheard your question, Your
Awesome.
Honor. I think if the defendant, if the non-moving party responds to the motion with affidavits,
Saying they're
Well, I
I think
Boston
that would be a
residents?
different case.
I thought I said, assuming you've engaged in petitioning activity, if in fact your conduct was to create a bogus lawsuit in the sense that selecting 10 people who are not good faith plaintiffs, and the case were dismissed on that basis, you said no, there would still not be liability for abuse of process.
Well, but I think that's a different question, though, whether that amounts to abuse of process or whether it would satisfy the
So
the
you're
non-moving
saying,
parties.
then my
No, I
question
think
was
there's
a bad question. I was
there's a-
trying to get at whether they would still be able to satisfy their burden of showing that there was no reasonable basis in fact or law for your claim.
They'd be able, if they
Okay,
had
all right.
affidavits in support of all the things that they've alleged in this case, I think that there would be a basis for the judge to deny the motion.
Well,
But
not
what
most of them.
what they've done in this case is the council's made its threshold showing that the case is based solely on petitioning activities. Once that, under Duracraft, once that threshold showing is made, the burden shifts to the non-moving party to come forward with real evidence. The whole point of the anti-SLAPP statute is to create a procedural mechanism for a trial court to cut through the allegations in the complaint, to cut through bare allegations, and look at actual evidence. And so after the threshold showing is made, the burden shifts to the non-moving party to come forward affidavits. And, Your Honor, if the town had come forward with affidavits showing that there were 10 Boston residents,
Well, now I really am confused, because let's say any RCC had brought it in its own right and the case was dismissed because they didn't have standing. What about that? Could they then have brought a SLAPP suit saying there was no reasonable basis in fact or law because you never had standing?
could they bring an abusive process claim?
No, would they survive a SLAPP statute? They bring an abusive process claim against you.
I don't think so, Your Honor. And I think it's because they could possibly raise a Rule 11, a sanctions issue in the initial litigation, but I don't think there's a subsequent abusive process claim if all the council was trying to do was to get into court with the object of having the court void the contract between Hanover and Callahan. If that's
So
the
it's
only
implicit
object-
in it is that the Fordyce suit had to be a legitimate suit. Is that what you're saying? I mean,
no,
in other
there's-
words, if it had been brought by 10 Boston taxpayers,
Yes.
and that wasn't discovered till afterwards, okay? So you have this whole case, it isn't discovered till afterwards, and answer to Justice Cordy, then Hanover does what it does, you would not have a anti-SLAPP motion at that point?
Well, I don't think Hanover, if all the council did was somehow file a lawsuit for which there was no standing, and the council's only object, it had no ulterior motive as it's defined in the abusive process,
Right.
the elements of an abusive process claim. If it didn't have the ulterior motive, if it filed a bogus lawsuit,
Right?
knowing that they were actually 10 Boston residents, they could be responsible under the sanctions rules in the initial
Right,
case,
but
there
in
wouldn't be a
terms of anti-SLAPP, would you
but there
have an
would-
anti-SLAPP?
No, because there's, well, I guess I'm not sure I understand what your question is. What I'm saying is that there's no subsequent abusive process claim here.
I get that.
That's what I'm saying.
All right, we'll have to leave it there. Thank you.
Thank you, Your Honor.
Morning, Your Honor. If it pleases the court, James Toomey for the town of Hanover. First of all, I'd like to focus here. We are dealing on the threshold issue, and the threshold issue is the initial one wherein the defendant, I'm going to call them the union, needs to show that they're involved, that the case is based upon petitioning activity. That, I think, occurs based upon the typical Rule 12b assumption that the pleadings in the complaint are accepted as pleaded. In this case, we do plead that this is a bogus lawsuit. We plead that this is a 10 taxpayer lawsuit in which 2 of the taxpayers who are represented as being plaintiffs were not consulted, never consented to become plaintiffs, and weren't. And this is kind of a special case because of the nature of Chapter 40, Section...
May I ask you a general question? Is it your position that a union could not support petitioning activity unless they were a party to the case? Could they be in the background and support 10 taxpayers?
Certainly, they could.
And pay for their counsel?
Certainly, they could.
So they don't have to be a named party.
Well, but here's where the issue comes. The claim here is for protection for petitioning under Chapter 40, Section 53. In order to petition under 4053, first of all, the underlying action that you bring in Chapter 40, Section 53, there is no constitutional right. The case is under 4053 by this court. Make it very clear. It's a distinct, special statutory remedy that, and the remedy of enjoining illegal appropriations is not available to individuals, to the union, or to anyone other than 10 taxpayers coming together in the town, from the town, 10 taxable inhabitants, in order to pursue the equity, the restraint of the illegal appropriation. So what I'm suggesting here is the only way someone can claim petitioning protection under Chapter 4053 is to constitute 10 plaintiffs who have the right to petition.
But you didn't file an affidavit in response to the motion, is that correct?
I did not, because there has never been any contest of the allegations in the complaint that 2 of the plaintiffs did not join in the case and were not willing participants. And that was never contested by the defendants. We're in the threshold area here where the town has no burden to come forward with anything.
Well, they do in
If
a
we
59H.
conclude that this was petitioning, then the burden shifts to you to present evidence
That's
that there was
correct,
no
Your Honor.
reasonable
That's
basis
correct, and I'm
in
saying
law.
you don't get there. I'm saying you don't get to shift that burden, because it is
But the very
petitioning.
theory- The very theory of suing NERC, who is not a party, and claiming it engaged in abusive process, has to be that NERC enlisted the others to file the suit. Isn't that the theory of your case?
Well, no, the theory of the case is that NERC did not make an improper enlistment of plaintiffs, although it represented that it did. It did not have the requisite plaintiffs in order to bring a 40 Section 53 case.
So why is that abusive
And therefore,
process?
it's not protected petitioning. It isn't petitioning. The only way you can petition under 4053 is if you got 10 taxable inhabitants. Otherwise, you don't have the petition. And that's due to the special nature of Chapter 40, Section 53, in which the court has consistently said, you don't have the 10 taxpayers, you don't have the,
Why is that abusive process?
well, I think the problem is how do you fit that into things? And I think that's a separate issue of whether it's an abusive process in terms of whether the misuse or the misrepresentation then brings you to the abusive process.
So
Because
would
you've
you
used
say-
process, you've used it improperly, we maintain it was for another purpose. But
What's the other purpose? The purpose was to stop this contract.
the purpose was to get it awarded to someone else, is
Well,
what our
well,
petition is.
oh, but that's-
we
that's a-
acknowledge
that's
that,
a-
we acknowledge there's no evidence of that in the record, because we're saying that in order to have the petitioning act, in order to be petitioning within Section 59H, they had to come within that statute. They didn't. It goes back to Corbin, which says
Petitioning
it
in the
has to
legal
be.
sense of filing a complaint. But if you take it more broadly as a petitioner, one who can seek redress from the government.
Yes, Your Honor.
And knowing that the union, as you call it, is not a taxpayer, why can't they be petitioning, standing behind the 10 citizens? Do you agree with that proposition? At first, I thought you said you did, but then
Well,
you're saying you didn't.
the issue is can't-
And put forward the 10 taxpayers. Let's say there are 10 taxpayers, and they're behind it. That's okay?
But
Because they can't do it themselves.
no,
They're
I would
petitioning.
suggest that they are not a petitioner under Chapter 4053 within the meaning of 59H because of Coburn, which says it has to be your own right. And the only way,
So even if they had 10 legitimate Hanover citizens, that wouldn't be enough? That's what
that's what I'm
Justice
saying.
Duffy-
Yes, that's what I'm saying, Your Honor. I am saying that because of the special nature of 40 Section 53, the only way you can become a petitioner, and it goes to the language in the statute, which this court interpreted in Coburn, which says it has to be your own right. Well, NERC cannot have a right under Chapter 40, Section 53.
So I'm confused about something. I think I understand what you're saying, but I'm confused why you said something earlier. You said earlier that 2 of the 10 taxpayers had not authorized a suit in their own name, in their individual names.
That's correct.
That's totally irrelevant to your argument, isn't it? Your argument
Well,
is that
but
the union
yeah,
cannot petition.
No. There's a difference between can't petition and whether they're protected by the statute. I'm saying it is not protected by the statute because they weren't asserting a right that they had. They had no right to petition. Now, in addition to that, I'm saying that there's a second prong in terms of the analysis, the threshold analysis of is this petitioning activity. And that second prong is it solely due, in the cases, I'll say this, is the activity being sued upon solely based upon the petitioning activity. And if there is any other element or additional conduct which is complained of, then they do not make their threshold case. In this case, we have the additional element here, which was that they knowingly went forward with less than 10 plaintiffs while representing that they had 10 plaintiffs.
So you, I take it then, your argument is the burden never shifted to you under the anti-SLAPP statute, because while they're making a derivative claim or an indirect claim of petitioning, it was incumbent upon them in their threshold case to establish that the 10 named petitioners, in fact, or that the 10 people named in the lawsuit as 10 petitioners had authorized the use of their name.
That is correct.
But what if
That's
they-
part of the union's threshold shown.
That is correct, because otherwise they have no rights under Chapter 4053, and they're not a petitioner under 4053.
Do you agree that at one point, at some point, while the Fordyce case was pending, there were 10 taxpayers who authorized that suit to be brought?
Absolutely not. Our
Do you
complaint is very
allege,
clear.
do you allege that that
Absolutely. Page 3
Never?
Page 3 of the complaint, Your Honor, is that there were two.
that's initially, I'm saying, they got replaced?
Yep. Well, one of them got replaced further down the line, but there was a period of time extending up to the point where we were before this court on the case, when there were never 10 taxable inhabitants of Hanover who were willingly participating in that case. And that's what our complaint alleges. Now, they did replace one before we got up to this court, but there was a period of time in which there were only 8 legitimate plaintiffs. Then there was, following that, when one of them was replaced, there was another period of time when there were only 9 legitimate plaintiffs, including when we came up to this court.
Is that a curable defect?
No.
Why?
This is jurisdictional. Chapter 40, Section 53,
Didn't move to dismiss, though.
we didn't know it. We
Well-
accepted the allegations of the complaint at
Well, that's,
the time.
So
We
let
we
me-
brought this when it came to our attention that they were not willing participants in the case, and that's something that came up much later in the whole situation. So there was no way that we would necessarily, not having discovery. Remember, this case was one that was being done on motions. It was a preliminary injunction case. And until someone came forward and that information became, the town became aware of that information, there was no ability to move to dismiss or at that point. And so as a result, the court was, by the actions of the union, the case went forward when there was no jurisdiction in the Superior Court, the Appeals Court, and in this court here.
Let me make sure that I understand your argument. The SLAPP statute refers to a party's exercise of its right to petition.
Correct.
Do you agree that a group which organizes others to file a suit, that group is exercising the right of petition?
If the right to petition that they're seeking to use, they qualify for, well, first of all, if the group itself does not have the right to petition under the particular vehicle that they're trying to use to get into court, they can't petition.
So basically, you're
They're
saying
excluded
that
from being a petitioner by law.
if
The
the
statute says you can't petition.
If the
Sorry, Jim.
ACLU cannot be a party to a suit because it has no standing, but find somebody who does have standing, that the ACLU is not exercising a right to petition.
That's correct. That's correct.
So it may not be anti-SLAPP jurisprudence, but how is that an abusive process? If they got the wrong, I mean, they made a mistake.
Well,
And
and we've wrestled with this, Your Honor, how that fits into the abusive process issue. I agree, it's not anti-SLAPP, but I think it works into the issue of the misrepresentation to the court, I think, then goes to show that this really wasn't about the taxpayers of Hanover. This was about something else. So I think that's how that evidence helps to show the ulterior motive here, because it couldn't have been.
but they had the same motive as the lawsuit was seeking. They weren't seeking some outside purpose.
Well, we would disagree with that, Your Honor. But again, we're not at that stage in the proceedings. We don't purport to have presented evidence on that. And again, the one other,
I'm just want to go back to Justice Gans' question. You would say that put them aside. The ACLU could not do this because could not bring, if you sued the ACLU for organizing this case, because it thought, let's just say, the ACLU thought that the meaning of the bidding law, what fraud meant in the bidding law, was what was alleged in the complaint, and that it was enough, and it should have invalidated the contract awarded to Callahan. But it couldn't bring a suit, so it gets, and maybe defectively gets, 10 taxpayers. The ACLU, well, let's say it doesn't. It legitimately gets 10 taxpayers. And you sue the ACLU, just the same as the NERCC. They have no constitutional right to do that?
not with respect to Chapter 40, Section 53, because there is not a constitutional right to bring that action. It's a limited,
They didn't bring it. They got other people to bring it.
well, then the only rights they get are those that would be derived from the people who could legitimately bring it.
Well, that's what they did.
And at least in that situation, I still don't see how they could get any rights under Chapter 40, Section 53. For support, the statute provides protection of its right.
Well, it is
and-
its right to petition the government
its
to
right-
suggest that the fraud was,
It's constitutional right, and in this case, we don't have a constitutional right. There is no right to sue the government for equitable relief absent 10 taxpayers under 4053. That isn't a constitutional right, and that's what the statute protects. It says it's the moving parties, and then it refers to it as its constitutional right. So if we can't identify a constitutional right in the person who is claiming the special motion, then they aren't petitioners, and they don't have protection under the statute. That's our position. Thank you
All
very
right,
much.
thank you, counsel. We'll take our break.
All right. May I have permission to submit a Rule 22 letter addressing a couple of statements?
Yes, you may, and of course, counsel can respond to your letter.
Thank you, Your Honor.
You're very welcome.